hearing today, simulation. So I have Jadita and Richard, DCF attorneys. Okay. You two want to sit together, or? Okay. Jeremiah, you may be alone today. Joe sent me an email that he was in court.
Okay.
So we'll see if he comes in. I'll have him submit you. Sandra is the investigator. Patricia's the GAL. Tim represents Alicia. Ash Jason. Dej Jonathan. And Lester and John. How about you? You two want to sit together? John will go to Lester, or Lester move to John. As you both represent Lee. Okay. You won't be hidden behind the post though, Lester, will you? How about you guys move down one, Richard and Jadita, and then John will sit over there. So I'm anticipating that this may take both classes, and if it does, what we'll be doing is the medical neglect IFA case after spring break. So what I'll do is by Thursday, we'll figure out your roles for that role playing. We'll end up skipping that material and gay youth. I sometimes cover later on with chins. So chances are we'll do that. And usually the mental health material, I get a speaker, so I'm gonna be shifting things around. By Thursday, we'll figure it out. We'll see how far we get today with this. Maybe we'll finish it today, who knows. The other thing is I sent an email for anybody that's interested in doing a visit to Billerica House of Correction. It's the last Friday in March. If you are, I need your social security number and date of birth because the prison needs to run a check before you enter. It's usually a pretty good visit because the lawyer for the prisons Lee Gottenberg usually is around and he'll talk to you guys. And then a number of the administrators there will meet in a conference room. They go through the rehabilitation efforts and the setup of the prison system in Massachusetts. And then we do a tour of the facility. And I like the tour because there's the old part of the facility as well as the new. Has anybody been there before? So it's really interesting. So if you can make it, it's just voluntary. Let me know. And just give me the, your info so that I can provide it to them sometime before that.
What is this?
Friday, March 29th. We usually meet in the parking lot, and then I let them know you can't bring anything in except the keys, no cell phones, no wallets, nothing. So we all meet in the parking lot, and then they come out to get us, and they shuttle us in at 9. And usually the conference room, the conference is half hour, maybe 45 minutes. Then going through the prison takes another maybe 45 minutes. We usually finish before noon time, and then we go out to lunch to a local place. So it's, in terms of your time, it'd probably be 9 till 1-ish or so, again on Friday the 29th. You can let me know up to, I can take 18 people, so I may open it up to some of the writing classes too, depending on the availability. So, you know what, if you could just send me an email either way, I can't come because of work, that would be great. So just so I get an idea of how many others I can invite. Okay. Any other questions?
The other email about the Suffolk law thing.
Oh, yeah.
When I looked at it, is it true that that's $69 to go?
Yeah, Suffolk Law has their own, juvenile justice center, and they put on really good conferences that are much cheaper than MCLE conferences. And their material, when you sign up online, they usually send you nice material online as well, electronic material. And Justice Agnes, who teaches here and also sits on the appeals court, is actually one of the participants that day. It starts at 2, and they're usually really short. This one is longer because they're gonna do a movie afterwards that you can, stay for or not, depending on. Yeah, 69. I looked, Jeremiah, to see if there was a different price for students, and I didn't see that. I just saw $69, so. All right, ready to start? So I will play the facilitator, for lack of a better word. And what I'll do first is we'll go around the room and just introduce yourself, but also, if you could, in just a sentence or two, tell me what your position is. Position, in other words, your legal position on the CMP case, on the criminal case, both, depending. For example, these attorneys are obviously involved in both. So I'll go around the room, starting with Jadida.
Hi, Jadida Sorrell, DCF attorney. We believe that the children should be committed to DCF custody because of the.
Just raise your voice a tiny bit.
Oh, sorry. We believe that the children should be committed to DCF custody because of the abuse by their father.
Okay, so, and Richard is your co-counsel.
Yes.
Do you want to add to that?
Just that the objectives for us are the permanent custody of the lead children right now, and possible termination of parents' rights, but that's dependent upon the criminal case.
Okay, so far you have not filed a motion in the CMP case, or changed your goal to termination. You're just looking for custody right now in the care and protection case. Okay, all right. So John and Lester.
John Nealon, the attorney for the lead in the care and protection case. It's my position that, it's our position that he should maintain custody of the children, as there's no real evidence of abuse.
How about if Lester concentrates on the criminal case,
I'm
which you
Lester
represent?
Carl-Manizais.
Okay.
I represent the defendant in the criminal side. And it's our position that there are constitutional issues here of confrontation
All right.
against the accuser. Furthermore, the alleged plaintiff, the children in the case, want to remain with their father. So we're moving that the father should maintain custody and be allowed, if this criminal charge is pursued, to have the children and the father in court together, not on videotape or in some other method.
And right now, he's seeking trial in both cases. You're not, you have not spoken to your client about admissions yet. Is that correct?
That's correct.
Not yet.
Okay. Yeah.
Ash Husson, attorney for Jason.
How old is Jason Nash?
Jason is 10 years old.
9.5, right?
Yeah. I am-
You know why, right?
Yes.
Okay.
Yeah. Seeking to work towards the goal of reunification.
Going, an attorney for Alicia. We desire to have Alicia return to her father.
And Alicia is 12, correct?
Yes.
Okay, thank you.
Hi, I'm Cassandra. I'm the court-appointed investigator.
And I will come back to you to relate what you investigated and the summary of the facts. But what is your ultimate position?
My ultimate position is that as a result of the investigation, there's substantial evidence that demonstrates that the father is not a fit father and that the children should be, no,
That's not what your report indicates.
that's what, yeah.
You're the investigator, correct?
Yes.
I'll come back to you.
Okay.
Nadej?
My name is Nadej Lewis. I'm representing Jonathan. He's 3, and my position in this case is to try to find Jonathan a permanent home to be adopted.
I'm sorry?
To be adopted. By,
So you would be supporting DCF's not only care, well, right now, the DCF has not moved for termination. That's why I looked at you quizzically when you said, referring to a permanent home to be adopted. And we'll come back to DCF. DCF has so far filed a care and protection petition, and they say that they're seeking custody. Their goal is not as of yet termination.
temporary
support
I do
DCF's goal
support
currently? Okay, all right. Patricia, you're the GAL?
Patricia Stellman, Guardian ad litem for the children, and my position is that I agree with DCF that the physical custody should be given to DCF
And,
for care and protection.
okay.
Jeremiah McIntosh from the District Attorney's Office. I feel the father needs to be incarcerated for child molestation.
Okay, so you're going forward in the trial, well,
Criminal
depending on
aspect.
what the purposes of, if we can achieve some resolution of all the cases, that's why we're here. Sandra, can I come back to you?
Yeah.
Okay, and I understand what you were saying, that, temporarily you are supporting, but it looked like that your
making certain
your
recommendations.
supplemental report, go ahead, I'm
Yeah.
sorry.
Okay, so the recommendations are to maintain legal and physical custody of the children. Of course, the Department of Social Services, but there are definitely recommendations in the service plans as to certain things that should take place, such as, of course, a referral for the father for sexual offenders, and a referral for all three children in regards to the sexual abuse, the trauma.
So if those things take place, you would be supporting reunification?
Yes.
Okay.
Yes.
So, let me have you, if you would, because you were the investigator, appointed investigator, summarize the case, just briefly, summarize at least the care and protection case.
Okay, so going from the beginning.
Yes, again, just a summary in terms of what you did and who you talked to and what led you to your recommendation of, currently temporary custody, but possibly reunification.
Okay, we investigated the reports that were made to the social worker.
Okay.
Which there was inconsistent statements
Who
made.
did you speak to in the course of your report, in investigation and your ultimate report?
The worker,
Okay. You
The
spoke
worker
to Ellen,
and
the social worker?
the social worker,
Mhm.
and the officer.
And you spoke to Kathy?
Yes.
Okay. Did you speak with the children?
No.
Yes. Yes, you did. Because you're the investigator.
Right,
You
okay, yes, I
investigated
did,
the
I
whole
did.
family, okay,
You're right, you're
all
right, you're right, you're right.
Okay.
So the officer, the worker, and the children. And what transpired out of that was the statements that were made to both the officer and the worker. At some point, they were inconsistent. And so, at the end, the fact that remains is that the father was inappropriate with not only the children, but the friend, Justin. To be more specific, having the children undress in front of one another, having them perform certain sexual acts with each other, they were just totally inappropriate. My investigation also shows, which also lines up with the worker, that the father explained how it all stemmed from the loss of his wife, being discharged from the military, and having all these issues. Not only that, I think he stated he had some sort of mental or emotional issues. But still, the kids at the time of this report, living with the father was just highly inappropriate because of the sexual acts.
Where are the children right now?
Right now.
Where are the children right now, I'm sorry?
What do you mean?
Where are the children?
They're with, yeah, I can't remember his name. I can't remember his name, but the uncle.
Okay, they're with their uncle.
The uncle.
Okay. And how they doing?
They're doing okay, but they want to return.
They going to school?
Yes,
How they doing in school?
they're doing okay. But the issue is that they want to return back to the father. And that alone is kind of having an effect on how they're performing and how they're feeling in school.
Okay, I'll come back to you. Let me hear from the department since you are the petitioner in the protection case.
I'll start by saying the department, our goal is, of course, to eventually reunite children, families. We don't,
You've heard and you've read the investigator's
Right.
report. Is
Yeah.
reunification a possibility?
and that's where I was going.
Okay.
Again, we ultimately would like to, but from what we've seen, in the investigation reports, at this point, we don't think reunification is what's best for the children, especially since the father has a pending criminal case, with similar, charges to what has been done to his own children. We get that the children want to go back home, and it's sort of taking a toll on their schoolwork, their academics, but at times, children don't always know what's best for them, and right now, the department thinks that them being placed elsewhere is what's best for them at the moment.
Well, let me ask either one of you, Richard or Jadida, and this is my concern, that, one of my concerns, and that's the reason for this mediation. If this case were to go forward to trial, what is your evidence? Richard?
One of the biggest concerns we have at DCF is the fact that the children are now recanting either all or portions of the testimony right now. As you know, DCF.
And I've heard, and we will hear from Ash and Tim, at least Jason and Alicia's attorneys, that they are not going to be testifying if you call them, whether they're going to invoke some kind of privilege, but that I've been told that they're not going to testify. So what does that mean?
With the department, the biggest thing is that we have to act within what's best for the children. And citing custody of Tracy and the adoption of Carla cases, multiple.
Carla or Carlos?
Carla.
Carla, okay.
It allows for hearsay and also multiple levels of hearsay, as long as the investigator, which I believe in her report, she's interviewed parties who have heard or had information regarding the statements made. by
Okay,
the
so
children.
you're going back to the cases that dealt with hearsay within the investigator's report.
Yes.
So I think I agree with you legally, and I'll hear from the other attorneys, at least Lee's attorneys, as well, regarding hearsay within the investigator's report. I think that you probably would not have a problem at trial if the investigator were going to be, you know, her report is already in, but if the investigator is available, and she will be at trial for cross-examination purposes. So you'd be able to get in, I believe, that she spoke to Alan, she spoke to Kathy, the two initial investigators, both from the police end and DCF end. You'll be able to get in what she says about her conversations with the children, about her conversations with Lee. But is that going to be enough?
I believe it's going to be to.
It has to amount, I'm sorry, to clear and convincing evidence of current parental unfitness. So the best evidence that you would have had, and I think that's what you're going to have a problem with, and I'll open it up to Lester and John and Alicia and Jason's lawyers as well. If you could possibly somehow get Kathy and Ellen to testify about that initial questioning, that's when it appears that, I mean, look, no one ever knows unless there's physical evidence when there's child sexual abuse, except for the, abuser and the victim. But if in fact they were victimized by Lee, then that first conference, that first questioning was the best. However, when either of them get on the stand, what are the legal problems going to be? John or Lester, I heard one of you say something about hearsay before.
Well, Your Honor, with all due respect, I'll get to hearsay shortly, but it's clear that Article 12 of the Massachusetts Declaration of Rights and the Sixth Amendment to the United States Constitution require a face-to-face confrontation.
Well, wait, because I think that you're both counsel for both of the cases together. Can I just?
You can.
All right, okay. Because you're talking about confrontation, and that's an interesting issue. It'll be. I want to hold off on talking about the criminal case for a moment. But does it apply to the parent protection case?
Well,
Does Sixth Amendment and Article 12 apply in a case that you know, has at most a clear and convincing standard, which is not, you know, and Lee does not, you know, I mean, if it was only the care and protection case, and if your client had not been criminally prosecuted, he's not subjected within the care and protection case to a deprivation of his liberty. Or is he?
Well, he's subject to losing the right to lose his family.
Right,
So that-
but, go ahead.
Well, I was just going to address, and the investigator's report is admissible, it's part of the paperwork of the case, but if you look at some of the cases like custody of Michael, you have to have a chance to confront the people. So not only does the investigator have to be on the stand, but some of the sources of the information, the children have to be on the stand. You don't need
I
to-
don't know that any of the cases say that, counsel. That the children have to testify. I believe there's no case that says the children must testify in
But
the
it
care
could-
protection case.
I think that might be an independent.
Ash wants to talk next, so go ahead, you finish.
Yeah, I think that might be an independent determination of their ability, their capacity to testify. But in the cases where the children have been unavailable, there have been times when there's been a confrontation problem. And even though the report was in the papers of the case, it wasn't meant, it was redacted when it was in the.
What are you talking about now, the report, when you said the report?
The investigator's report.
You're still talking about, the court-appointed investigators or the Ellen and Kathy, police?
The
and
24, the section 24.
The 24 is merely the petition that DCF filed. Do you mean Cassandra's report as the court-appointed investigator? She's the independent investigator that I appointed when the case first started, who wrote her report and then her updated report about a month or two later.
Well, in the case that I'm talking about, it refers to it just as the investigator's report.
Yeah,
It's
and it's probably, it might,
But it
yeah.
says pursuant to general laws.
Yes.
Chapter 190.
Yes, and that's Cassandra in our case. But that isn't the questions that, again, I believe that the problems with this case revolve more around Kathy and Ellen getting in the out-of-court statements of the children rather than the investigator's report. The investigator's report is going to come in. I mean, you might be able, as you said, to challenge her sources, challenge her information and so forth, but for the most part, it's going to come in. I don't believe, but the problem is it alone will not amount to clear and convincing evidence. So the question then becomes, and Ash is dying to answer it, I think, about how and in what way can Ellen and Kathy testify about that first, about the first questioning, first interview with the children.
Well, I don't have an answer to that.
Oh, okay.
But I do have, to kind of go along with what you were saying, for a child's out-of-court statement to be admitted substantively, there had to be other evidence independently admitted that corroborated those hearsay statements.
Okay, now, are you reading from a case that involves the statute?
Commonwealth v. Collin.
Okay, now here's the problem, because you're representing Jason in the care and protection case. Does 233-81, the Collin case, and now anyone can answer this, apply to the care and protection case? Does Commonwealth v. Collin, which deals with 233-81, does that case and that statute apply to the care and protection case?
Yes.
Patricia's saying yes. Point to it, tell me where it does. How does 233-81 apply? to the Karen protection case.
Isn't there another Jason? Because he's learning how to talk on the
There's 23381, John.
No.
No,
because
why
it's-
not?
Because it's not a criminal proceeding.
23381 and Commonwealth of Holland, and I'm going to let, you know, and we'll get to that with, you know, Jeremiah and Lester in terms of the criminal case. So the standards of, you know, your client, Ash, Jason, testifying in the criminal case are different from the standards in
The care
the
protection.
care and protection case. So Ash, can you instead cite a case that involves 23383? And in what way can DCF get in Jason's statements in the care and protection case?
Does that come from the Burnstrom case?
No, anything that starts, here's an easy answer.
Anything that-
Any of the cases that start with Commonwealth versus,
Okay.
all right, that are going to apply to Lee's prosecution. Any of the cases that are care and protection of, are gonna apply the care and protection case, and anything that's adoption or termination, may apply if, but possibly in the future, because DCF has told me that they're not looking for termination yet.
Care and protection of Robert?
You're going too far back. We're concentrating on the sexual abuse cases.
Okay.
Robert is just the case that set the standard, remember, for the 72-hour hearing.
Okay.
So we're beyond the 72-hour hearing now, and we're looking to, should these cases go to trial, or can we achieve sort of like a package deal for this family in the criminal, in the care and protection case? So what case, either Ash or the department should be thinking about this, or even Lee's attorney, what case stands for the standard as well as the statute by which Jason's statements to Ellen and Kathy might come in the care and protection?
Custody of Michelle.
Well, again, if they're not, if they're purely hearsay, and we'll deal with that, but I want to look at the statute first, because that may be DCF's best bet for at least getting Jason's statements in. A lot of the other cases just dealt with hearsay, with state of mind, excited utterance.
You talking about 119, section 51D?
No, we're talking about
82?
233 right now.
82?
It's section 83, yes, because 82 is your civil. Section 83 is your care and protection. Okay. And what case that you might have, you legal legals, would be helpful about whether out-of-court statements of children in care and protection cases should come in and in what way they come in. Look, this is what we do, what we'll do while you're looking for that, since we already know Colin, let me hear from Jeremiah and Lester or John about, again, to what extent and what the standards would be, Jeremiah, since you're the prosecuting attorney. How can you get Jason's statements in under 23381 in the criminal prosecution of Lee, looking to both the Collin case as well as 23381 itself.
What was Jason?
Jason's 9.5, so he's under 10, he's satisfied, you know, that's why I said 9.5, so he could satisfy that requirement. What do you have to do as the Commonwealth to get Jason's statements in through Ellen and or Kathy?
Just submit them.
What's that?
Oh, well,
There has to be other
they have to
cooperating.
testify, not the kids, the people that heard the statement. So the person who the statement was made, who heard the child make the statement testifies to what they heard.
What else?
Physical evidence, but there wasn't any, right?
again, we're looking at the standards of 23381. And again, it goes to, and Lester, you mentioned at the beginning, constitutional rights of the client, the accused. In order for those statements to come in, what does 23381 mandate?
If the declarants are available to testify without undue prejudice, without the showing of some irreparable harm to them, then
Turn it around, because you represent Lee. So I'm
That's right.
assuming you are going to be saying something like Jason is unavailable. So is unavailability, I'm sorry, wait a minute, I just lost my train of thought.
Only-
They have to show that he's unavailable.
yes, but only if
Mhm.
the unavailability is predicated upon some irreparable harm to the declarant testifying in person.
So unavailability, and we'll discuss that. What's the other requirement? And Ash mentioned it.
If it would avoid severe and long-lasting emotional.
No, you mentioned it just a second ago almost.
Of corroborating evidence?
Yes.
Okay. But on our end-
In addition to that, you've got to give prior notice. You already did. Let's assume that, okay.
But I mean, we could
You're going to
also-
have to show at a separate hearing before trial, right, that there's a compelling need for this procedure. You've got to show it by preponderance of the evidence. There's got to be this separate hearing regarding reliability where the judge has to make findings. And as Ash just said, there has to be independently admitted evidence that corroborates the out-of-court statement. When we get to the care and protection end, we're going to see that all those requirements are relaxed, and we'll discuss why. John, you wanted to say
Yeah, I
something?
just wanted to say and I don't know the specifics of the law, but it seems like there's not a lot of hearsay exceptions in this situation.
Right.
Jason's admissions, and also, it's kind of a formal investigation, so it would lend itself towards being testimonial evidence, which is not, which can't be included with, and it's a violation of the Confrontation Clause. So
Wouldn't we also, as a DI, I would think our case would be stronger if we would petition the court for a modified testimony where Jason's in another room with the judge and the attorneys, or...
Hold that thought. I just want to clarify the 23381 situation first. But that's a whole other, with the Bergstrom cases
Yeah.
and Emerald and so forth. Lester, you
You
want to
know, I wanted
comment
to
on that?
respond to the
Oh,
district attorney, so.
Okay, can we finish the?
Of course.
Okay. How are we gonna finish? Let me ask you, Jeremiah,
Yeah.
you would have to show under the statute unavailability of Jason.
Right.
So how would you be able to show that?
If I wanted Jason to be unavailable, I'd get a child psychologist
To say what?
examine him and say he's not competent to stand trial.
Well, would it
Or
be
do more harm? It was stress.
So would it be
trauma.
competency or trauma? That I think that trauma might be.
It'd be easier, most likely easier to prove the trauma.
Because
side.
I'm hearing that he's 9½, he does well in school, he
Yeah.
seems to be a mature young kid, so I'm not sure in terms of competency where that would be an
Yeah,
issue.
the trauma
I
side.
bel-
Yeah, it
Oh,
was
go
just
ahead.
facing his father, talking about this sort of thing in court. I'm assuming the child psychologist was most likely to say that the trauma that event would induce, maybe not rise to the level of irreparable, but certainly be harmful.
Okay,
And as a state, we're not trying to harm the child.
okay. Sandra, I'm sorry.
Well, for unavailability, there's only 4 ways you can show
Under
unavailability.
23381?
Yeah.
Go ahead.
Well, I just know this from evidence. I mean, I'm just thinking.
Oh,
outside of evidence.
unavailability generally.
Right.
Go ahead.
I mean, you have to be dead, exercising a privilege beyond the subpoena power or incompetent. So,
Mhm.
would the trauma fall under incompetence?
Well, there's a specific unavailability requirement in 23381
okay.
itself.
Okay.
Yeah,
Okay.
so these are statutes, this is a statute that's actually a hearsay exception
Okay.
for children that are under 10, children's out-of-court statements of
Can
sexual
you read the
abuse.
trauma thing?
I'm sorry?
You want me to read the trauma letter?
Yes, go ahead.
The court finds, based upon expert testimony from a treating psychiatrist, psychologist, or clinician, that testifying would be likely to cause severe psychological or emotional trauma to the child. So as long as you have somebody saying that, then he's on go.
On a side note too, what do you have to be careful about, whether you're the department as the petitioner in a care and protection case and or the prosecutor, when you have an expert that is testifying about child sexual abuse, and there are a number of the cases that go to this issue, what do you have to be careful about that they don't go too far and do what, Ash?
Well, it's only gonna, it's supposed to just aid the jury. You're not, an expert can't say whether a child was sexually exploited.
Exactly, and that's why the Collin case was actually reversed. It didn't really have to do with the 233-81 requirements. The court didn't screw up that way, but the judge erred in allowing the expert to testify that, in her opinion, the child victims were actually sexually abused. So that's what, again, the petitioner and the prosecutor has to be careful about, whether that, and that could be the expert's opinion, but the expert cannot go that far and testify to anything that intimates that the children were in fact abused, John.
And that wouldn't come in for the truth of the matter. That would be an exception, right, where the expert would use the allegation as the basis for their opinion, for their expert opinion, but it wouldn't.
Well, since we're talking about experts, what can the expert testify about? And so that Collin deals with an expert, a number of the other cases also deal with experts as well. What can the expert testify about, Lester?
Well, as in the Fells Acres case, an expert can testify as to physical consequences of abuse or physical signs, I suppose.
So, for example, say that there was an expert who's been qualified and has dealt with battered child syndrome, right? How would that expert be able to testify?
The expert would be able to testify on the basis of his or her experience, and that the conduct of the interview with the subject would tend to either lend itself to an interpretation of abuse or not.
Does that last statement go a little too far? John?
Yeah, I think the expert is just saying, like, the record, I've looked at things that are hearsay that can be the basis of my opinion, but my opinion is just,
Don't talk hearsay for now. We're just talking in general right now about, if you got, if either side is gonna be using an expert, what they have to be careful about in terms of how they're gonna use the expert. We just went off the hearsay for a moment, since you mentioned the expert, so.
I would think the basic thing would be that the expert can aid the jury's or the court's understanding of the issues or the specific psychological problems that happen.
So say that the DA's office and or the department as well also want to put on an expert that is going to be talking about your client, Lee. Is that an issue? Could that be a problem, Lester?
Well, the expert, for example, in the case of Dr. Daniel Schulman, his testimony.
You actually have it. Go ahead.
Yeah, his testimony has been used to cast doubt on the interview techniques that are used with alleged child sexual abuse victims.
Okay,
And
that's another issue, but go ahead. Talk
well,
about
just
that.
that
That's
I think
a good,
that's,
very good point.
I think that's very important testimony that should be allowed. He calls it a positive reinforcement loop, where the interviewer subtly suggests to the child that he or she was sexually abused.
Yes.
And the child reads on a subliminal level that it will please the interviewer if I say that I have been, and a reinforcement loop then is established, and this is very important for a trier of fact to understand.
So I'm assuming that, at least in the care and protection case, if it gets that far, your legal strategy, both of you, John and Lester representing Lee, would be attacking the type of questioning that was performed, if in fact the judge is even looking to somehow admit the statements.
That would be one of the prongs of our strategy, in addition to the...
Can I get back to the evidence of, so suppose that Ellen, in the care and protection case, wants to talk about her conversations with Lee, and then there's going to be an expert that's also going to testify about Lee and whether he fits a certain category as a perpetrator. Is that going to be a problem?
For who?
For Lee. So I mentioned the battered child syndrome, which is okay for an expert to testify about, but can an expert testify that Lee fits the, and this should ring a bell to you, the profile of a batterer or a sexual abuser?
Yes.
Yes, what?
Yes.
It's okay?
An expert can testify. No.
No. And you have at least one case here, and I forgot what the name of it was, where that would be an error if the judge is going to allow an expert to say, oh, gee, Lee seems to fit, he's controlling, the wife died, whatever, he fits the profile. So profile evidence would be inadmissible. But again, the expert can be testifying about the characteristics of the children in terms of a battered child syndrome or fitting, but again, you have to be really careful that it doesn't amount to the ultimate opinion, the inadmissible opinion testimony.
Pretty much an expert witness can't make an accusation, but
That's
can
right.
can explain behaviors of a pedophile.
Exactly, like you said before, either you or John, aiding the jury, but not doing the job of the jury or the judge, right?
And also, if it was a criminal case, character wouldn't be an issue unless we brought it up. Unless Lee opened the door by saying...
Well, he's being prosecuted as a sexual abuser, right?
So you can introduce, because wouldn't that be sort of character evidence?
Well, it's profile evidence,
Yeah.
and that's what's inadmissible, the profile evidence, both in the care and protection case and in a criminal case. So we went off a little bit, but that's good that we discussed those issues that might be problems with both cases. So getting back, Jeremiah, to your 233-81 hearing,
Yep.
do you think you'd be successful if you moved for, because that hearing has to be held ahead of time before the trial, would you be successful in getting Jason's statements in under this exception and under the Collin case?
If I wanted to. Yeah.
Could you elaborate on that? Okay.
I just
I'm
think-
sure you want to as the prosecutor.
Well, no, I'm just thinking, based on how I read the case, I think it's almost stronger to try and get a modified testimony of Jason. Modified,
I don't know what you mean by that.
I mean, like the cases where they take the kids in another room where he's not actually.
I know you want to talk about the other room, we'll get to that.
But I can't do that if I want to.
Yes, you can do that too.
So I
You
can
want to
make
get
him-
his statements in.
Okay, but I can't make him unavailable than available.
Yeah, that's true. And
That's
you
what
know
I'm
what,
saying.
I'm sorry, yeah. But I heard from his lawyer that he's not going to testify. So much as you want to get him in another room or do the small tables.
Well, I mean, Okay, well, if he's not gonna testify, then yeah, assuming,
And I'm sorry, oh, wait, because this raises an interesting question. Suppose he does, and suppose you work with Jason's attorney and he says, okay. Under the criminal cases that you've read, do these attorneys have a problem with this, what is Jeremiah calling it, the modified?
the modified testimony.
The modified testimony.
Yes.
So, what's your problem? And you mentioned it at the very beginning, Lester.
Yes, that they're both state and federal constitutional
Okay, so give
prohibitions against.
me specific cases, give me specific standards.
Well, first of all, in Article 12 of the Massachusetts Declaration of Rights, there is a guarantee
Of what?
of a defendant's right to confront those allegations against
You're
him.
saying it, but you're not getting to the heart of it. What's different with the Massachusetts and the Massachusetts cases? So compare for Commonwealth v. Bergstrom, Commonwealth v. Johnson with Maryland v. Craig, for example.
Right.
Is it the fact that if it's just the attorneys and Jason, there's no face-to-face?
Face-to-face.
Right.
So what is it about Massachusetts that it's gonna be a problem with the procedures that Jeremiah is talking about? Is there a problem? What would you propose, first of all? You said modified, so how do you
Well,
want to
yeah,
modify it? So
I mean,
Jason's not gonna come in the courtroom, you're saying,
Ideally, I would prefer the ante room with the judge and the attorneys on cameras. All the attorneys have, the other attorney has, the other counsel has the opportunity to object. to the
Wait,
judge
who's
either.
where, tell me who's where, I'm confused now.
I can't remember the name of the case, but it's the judge, Jason, I can't remember, I think it might even be both attorneys. They're in an ante room. Everybody else stays in the courtroom and watches the
Where's the
proceedings.
defendant?
He's in the courtroom.
Okay. Isn't
And-
that the Bergstrom case?
I think it is. And then
And
he's
wasn't
watching
there
it
a
on
problem?
TV.
What does the SJC say about that procedure? Was that the Bergstrom case?
I can't really.
Closed circuit, yeah.
Yeah, it is.
So, is there something wrong with that, counsel?
Yeah, if it's gonna,
Tim's nodding.
if it's
Tim,
gonna-
even though you represent Alicia, you can weigh in, certainly.
We're trying to avoid severe and long-lasting emotional harm, trauma to the child. And in that situation,
But what's the holding of the Bergstrom case?
Well,
The defendant may be present unless his presence creates trauma. And you have to reduce adverse impact of testifying, so you can do it by electronic means.
Really? Does Bergstrom talk about the statutory procedure that the Bergstrom court actually held unconstitutional?
can't justify it in the presence of the defendant.
I'm gonna argue for it anyway, no matter what I say. Now, another aspect when I read this.
Oh, you want to move on, all right.
Well, no, it kind of makes things a little different when we talk about this.
Yeah, yeah.
Is that it's an undisputed fact that the father admitted that there was sexual abuse going on in his home. So we're not trying.
So you're talking about the first, that's a good point. So
So
the
to
first
me, as a
statement.
prosecutor, I don't need Jason, I'm not bringing Jason on to prove that it happened. The father already admitted it.
I have an issue with
What,
that.
but what, I think I'm gonna hear differently from his attorneys as to what precisely he admitted to.
Yeah, well, on the movie that we watched last week, it was talking about how only in very rare cases would it be considered a sexual abuse if there was no touching. And Lee didn't admit to any touching that I saw on the record. I thought he was very vague about what happened, and he was, I won't say anymore because I'm his attorney.
He didn't describe
So,
in
I mean,
detail.
he did say, I agree with you, Jeremiah, he did say something that both sides, I think, the department could get in, as well as the, prosecution. So that would come in as what sort of hearsay exception? So it's Lee's statements to Ellen initially, remember, when he called her, I forget if he called her or if he actually physically was in the office.
Right.
When he said, yeah, it's been going on, and,
Well, yeah.
I was abused as a child, so you're gonna be able to get them in, but under
Except-
what?
Well, it's different than what they were saying, because.
But no, wait, but
Parties
I'm
own
asking
statements
how you're
offered
gonna get
against
it
that
in.
party.
Tim?
Parties' own statements offered against that party.
Exactly, so you can get no problem with getting those in. Ellen's gonna
Right.
be allowed to testify verbatim as to what he said to her.
Right.
But, go ahead, you want to
Well, I
say
was
more
gonna
about
say,
that?
well, he didn't admit to the touching, like, in response to that, when I read this, it was, he was read the interview. He was read what the kids were saying. And he admitted to it, what they were saying, with the exception of the frequency.
So you're saying in the context of,
So to me, it's like, as a prosecutor, when I looked at this case, we're no longer proving whether or not he did it. We're trying to flesh out exactly what happened, how many times it happened, but
so if you had Ellen on the stand, how would she be relating this? So you have her on the stand, you're doing direct examination of her, right?
she's the DS.
Yes.
Yeah.
Yeah.
Well, I'm reading page 12 of the thing.
Okay.
I would be asking her, what?
And the same thing goes for Richard and Jadida, that would be.
Yeah, my questions to Helen would be, it says, notification papers were given of allegations in the statement of rights. Father read both prior to the interview.
So
it's like, I would want to, on the stand at that point of it, what exactly did he read?
Hearsay objection.
What did you
as to
give
what
him?
he read?
Yes.
What would be what's the basis of your objection? If the question was, what did he read?
What did he read, or what did the DCF attorney read?
Are you saying that she handed him something? I'm sorry, I just
Yeah.
lost.
Notification papers were given of allegations in the statement of rights. What papers did you give him?
What papers did you give him?
Okay, that's-
Yeah, the 51A,
Right.
report.
Okay.
Because that formed the basis of the interview after that point. That was the foundation that they were
After
talking
he read
about.
the report, what, if
Right.
anything, did he say?
Say that
Yeah,
called the
objection,
objection.
but then it's gonna come in by the opponent. So it comes in against him. It's not gonna come in against the kids.
Right.
Remember the Sophie case? I think it was the Sophie case.
Self-incrimination.
Yeah, so it's only coming in as against him in the care and protection case. But not as against the kids, even though the kids,
So to me, that's
support.
what made this whole thing different. She reads.
But here, again, and here's my problems with both cases. Department has the clear and convincing standard of proof. DA has the proof beyond a reasonable doubt. I mean, we're talking about snippets of stuff coming in. Is it gonna amount to enough in both cases? Let's talk about some other hearsay exceptions. What about Alicia's statements, Tim? He was a child molester and I hate him, for example.
At the time, was she over 10 at that point?
Yeah, Alicia's over, yeah, so we're not dealing with the statute, only with hearsay exceptions. So that would be like the Jennifer case, or, some of the other cases that you have relative to, unquote statements. By the way, I just noticed the profile evidence was custody of Eleanor. Remember Flanders? That's when the expert had testified that he demonstrated characteristics, blah, blah, blah. That's custody of Eleanor. There's other cases that stand for that in other criminal prosecutions, not just child sexual abuse. So Alicia's statements, whether the department seeks to introduce them or DA, and I forgot if she said it to Ellen or Kathy, but that doesn't matter. I'm sorry?
Excited utterance, is that what, state of mind?
Well, so let's talk excited utterance. Yes,
Yes, 'cause it's child
why we're here, yeah, because my father's a child molester, I hate him, that sort of thing, whatever it was that she said. Excited utterance, any issue with that? Do you think it's gonna come in? John?
It's usually, I think, if I understand right, it's usually before, immediately following, like within 10 minutes of.
Well, does it have to be that close in time? And are there
Depends-
cases to
depends on-
demonstrate that the excited utterance, or it's also called spontaneous declaration as well, something like that. That isn't it while the person is still, let's call it suffering, so it doesn't have to be just minutes later, right? So I think that there's not gonna be a problem with that coming in. But what
Would
does
that
the
be
judge
state
do?
of mind exception?
No, how does state of mind come in?
Present sense of
I'm
That
sorry,
was
how does it
stated.
come in and how is it relevant to, say, the Human Protection case? The Richard and Jadida, if you're gonna, for example, the department has Eleanor Caffey on the stand, and whoever it is that's testifying starts to say, well, Alicia said, and of course, you're gonna get objections from everybody. And then you're gonna say,
State of mind.
well, state of mind. And then the court's gonna say, well, how, what do I do with that? For what purposes would you be saying, oh yeah, it comes in, judge, for
It's an
state of
exception-
mind?
exception to hearsay.
True, but again, how's the judge gonna use it in the Human Protection case? Yeah, I'll let you say everything that Alicia said. And I'm letting it in under state of mind, right? If the judge is letting it in, Richard, under state of mind, what does the judge do with it in terms of the judge's findings and conclusions after trial?
You relied on it.
What? For what? For what purpose? For what purpose? Relies on it to conclude what?
He's not gonna rely that the father's a child molester, but how she feels about her father.
That's it, for state of mind.
What she thinks happened.
Yeah, so for example, the Jennifer case, how did the Jennifer case apply to that, the state of mind? What did the judge do wrong in the Jennifer case? That was a Human Protection case, I believe, yeah. Janita?
Well, in the Jennifer case, what I got from that, I don't know how the case is in front of me, but what I got from that is that, state of mind was used if the mental condition was relevant to the issue.
Well, and again, it's always gonna be relevant, Human Protection cases about children, so of course that would be relevant. But, again, how did the judge err, and how is it possible, that you guys might be making a mistake in just relying on a state of mind exception to get Alicia's statements in? And John?
The court said that the judge had really wasn't so much relying on the state of mind exception, but was using that and was basing most of his findings on that he believed the past events had happened.
That's what I'm trying to get at. The judge has to be really careful, and you can get them in and say, Judge, state of mind. Okay, I'll get them. I'll hear her. You know, go ahead, testify, Ellen, testify, Kathy, about everything Alicia said. But I can then only use those statements not for the truth that she was sexually used, as you said, Richard, but only to talk about her state of mind. So again, the judge is going to be faced with the burden of, is there enough here to find me unfit?
Wouldn't the judge have to take extreme caution not to rely on it as substantive evidence?
I know, exactly. I mean, the good thing is it's not, none of these cases are jury. Only the criminal case is jury. So in terms of the human protection, you know, the judge is supposedly an expert in this area, and that's why the judge has to make specific findings of fact and rulings of law. And even sometimes when the findings of fact are okay, a judge could still be reversed if the ultimate decision is unfitness when the findings just don't merit unfitness. So we've got another issue. You talked about corroboration before, Ash.
Yes.
So how does, and this was the Emerald case talked about this, how does fresh complaint, or what today the doctrine is called first complaint, come into play? Can Ellen and or Kathy in the criminal and or the human protection case be allowed to testify about that first initial interview based on fresh or first complaint. Lester?
Well, Amaro drew a distinction between a complaint made by an adult to whom the child confides or expresses an incident of moment, as compared to years later, the child telling her grandmother, yeah, this happened. And Amaro,
You talking about Amarillo, that recent CMP case that gave guys, I don't know if it's Daisy or.
I thought it was,
Emerald was a Violet Tukey.
Emerald was the Falzacred
Yeah.
Yeah.
case? Is that what you're talking about, Lester?
I don't recall.
Okay.
I thought what the case that I was referring to stood for was the judge did permit the allegations
complaint
made
witness
years
to
later
testify.
as the initial complaint, as part of the,
So wait, if you're talking about Emerald, I believe what you're saying is that, so the children in Emerald, and there were tons of them, that spoke to police officers, mothers, fathers, etc. I believe there was one where the child related to the mom maybe like 18 months later. Is that what you're talking about?
no, this was the
Okay.
case where
And
the
that
child.
still was allowed as fresh complaint, because again, even though with fresh complaint, it wasn't so much the passage of time that it had to be right away, but it was the child or the rape victim, whatever, still, you know, when complaining to this person, still suffering, still in the midst of, you know, the trauma related from the rape, from the abuse, and that's permissible. And I don't know if that's what you were getting at, but that's,
Ron, I don't recall the
Okay.
question that brought me to that.
okay. All right. What does anybody else have to say about Ellen and Kathy's testimony coming in as for, today it's called first complaint, and was I didn't give you that case, it's just a criminal case that set the standard in Massachusetts and changed from fresh complaint to first complaint. And so, I mean, back then, you could have Ellen testifying, Kathy, say if the mom was alive and the kids told mom something, and so you'd have a bunch of fresh complaint witnesses. But today with Commonwealth v. King, you can only have one witness, and it's the first one. And that's why I thought you were referring to, when you said grandmother, the
Yes.
case where the young girl was sexually abused, raped, told her mother initially, and then later on told her grandmother.
Yes, that was
after-
Amaro. The
No, that
child was
wasn't
only
Amaro.
4 years old. And
You're
then-
mixing up, go ahead.
And when she was 9, she told the grandmother, yes, this happened.
And, again, today, only the mother, that's what I'm trying to get at. Oh, today, only the mother, the first complaint witness, would be allowed to testify. But again, that's not the question I was asking. Is Ellen or Kathy's testimony going to come in under these doctrines at all?
Yes,
And how?
for a limited purpose of just aiding the jury.
There's no jury. Well,
Oh,
in the
but-
criminal trial,
okay.
certainly there might be, but.
Well, in determining whether to credit the complainant's testimony, but not to prove.
But here's the problem, you represent Jason and Tim, you
Alicia.
represent Alicia. Now, I've been told they're not going to testify. What does that do to first complaint testimony? Can Ellen and Kathy still testify?
Would
We
throw it
were the
out.
first people that they complained to, right?
Yep.
Can their testimony come in if the children are not going to testify? Lester?
I'm trying to remember the case where the judge did permit the interviewer's report, which recorded manually the allegations made by the children to come in, even though the children themselves did not testify.
The interviewer's report?
Yeah,
See if you can find the case while we continue on. Richard?
I think it's Avilas, is that the correct case?
Aviles, yeah.
Aviles.
That what? That I was talking about earlier?
No, that's the one that I believe permits first complaint.
Right.
That permits for, well, King set the standard first. Aviles mentions King, and I gave you guys Aviles, correct? Okay.
I don't
What
have-
is it?
I don't have it in front
You
of
don't
me.
have Aviles, okay.
I do remember.
Yeah, yeah.
Yeah, it's on page
Aviles,
329 of the packet.
Aviles is the case that I was just talking about. So, under Aviles,
Yeah.
both Ellen and Kathy could testify because they're the first complaint witnesses.
Right.
But my problem is, can they if Jason and Alicia are not going to testify? Because what do you need? What's the basis of allowing fresh complaint, first complaint in the first place? It's not really an exception to the hearsay rule, right? It's something else, John, right?
Yeah, I think it's
What's-
to support, bolster the victim's
The
testimony.
victim. So if you don't have the victim testifying, how can you possibly have fresh or first complaint? Because think of it, for example, you have a rape case. The victim goes, immediately to the police, right? The defendant gets prosecuted, the victim's testifying, the police is testifying, and even if the police, the cop starts saying on the stand, well, she told me, and defense says, hearsay objection. No, Your Honor, it's not hearsay at all. This person is testifying that the victim came and complained, right? This person is testifying to corroborate what she's going, or what she already testified to. She testified first, or what she's going to testify to. And again, the issue is Alicia and Jason are not going to testify. So how can the judge possibly let their testimony in as fresh complaint or first complaint as it's called today? I don't think you can. Does anybody disagree? Much as you would want to get it in as the DA or as the department.
I find it I get that it's to corroborate the victim's testimony, but in cases like this, when it deals with children who might be traumatized.
Well, and again, that's the reason why in the Camp Protection case, luckily Jason is under 10. So under 23383, and
Yes.
read the Rebecca case for next class. It is going to be easier for the department to get Jason's statements in under Rebecca and under 23383. And again, consider Jason and Alicia's statements coming in under any of these hearsay exceptions. We mentioned state of mind and excited utterance. I don't know if there's anything else.
I just have one question. I'm wondering, does the court give any more weight to like the same interview as opposed to the first complaint? Because where it's in a different
Wait,
setting, it's
now-
almost by.
Right, but here's the problem. So the children were actually interviewed, or tried to be interviewed at least 4 times. So there was the initial one that really yields the most for the department, and that's the one where we have all the hearsay and other issues. The same where they were hiding and they wouldn't say anything. Wow, what else am I thinking about? They were taken to, and it's probably not in your packet, but they were taken to a psychologist by the GAL, and they wouldn't say anything. And they spoke to the investigator, and it was a different story, So in some ways, the court will be able, through some of these exceptions and so forth, to get a lot of that in. But how do you assess it? How do you assess the significance of it? is it going to amount to clear and convincing of parental unfitness? Is it going to be proof beyond a reasonable doubt of indecent assault and battery and or rape, of the 2 minor children?
Can you use the fresh complaint if you get the testimony in through 23383? Is that?
Let's think about that for next class, because that's complicated. You want to start with that? Okay. Now, the other thing is, and I'll have Nadej also start with, now Jonathan, who's not a subject of the sexual abuse allegations, I've heard that Nadej's position is with the department in terms of the department having, custody and possibly termination. So how do you square your position with the fact that there are no specific allegations? And there are cases that would support that. So we'll start with Tim and Nadej. And we'll rehash or summarize, because I think we got to the heart of most of the issues with the case. And because of the holes in the petitioner's and prosecution's case, they may think about, putting on the table some kind of offer. So you might want to think about that. The department, what would you offer Lee short of trial? Same thing with Jeremiah representing the DA. So we'll wrap this up Thursday. So it looks like we will do medical neglect after.
Okay.
Yes.
Okay.